Hello, I'm Jordan Bentley, one of the attorneys at McIntyre Elder Law. And a question that we get asked pretty frequently in appointments is, what do I do if I'm deemed incompetent or I don't have capacity? Maybe my mother, father, or my spouse, is in that position and they haven't named a power of attorney. They haven't executed those. They haven't chosen an agent to act in their behalf. Well, the answer to that is a guardianship proceeding. That's where someone, usually a loved one, petitions the court to have you deemed incompetent and have a guardian appointed. It's a two-step process. So the first step, as I said, is petitioning the court to deem you incompetent and say that you lack capacity. That's not pleasant, it's not fun, but it's necessary if you don't have powers of attorney or another less restrictive measure in place to do so. After that, after the court deems you incompetent, the second part of the hearing is where the court will appoint a guardian. It's not always the person that petitions. It's not always someone who you would want or who you would have chosen. It can be any family member. It can be a third party. It can be an attorney. And the idea would be that you need powers of attorney in place so that you never have to be the subject of a guardianship hearing, right? Your loved one's never going to have to petition for guardianship. We're never going to have to present evidence and argue over who should be your guardian, and you'll be able to make that choice. So while a guardianship hearing can be necessary, and while we'd love to help you through one, it's much more beneficial to have powers of attorney in place and avoid ever having to go to court and have those things done. You can name a healthcare power of attorney and a general durable power of attorney, and those people are able to act on your behalf and make decisions for you when you can't. But if you don't do that, once you're deemed incompetent, it's too late to do it, and the only option is guardianship. And again, that's a court proceeding that you need to contact an attorney, and they'll help you with and walk you through the steps, and hopefully have the person who's petitioning for guardianship appointed as your guardian so they can make decisions and they can do things on your behalf in the realm of healthcare and also anything legal or financial as well. If you think that a guardianship proceeding might be where you're at, might be the right next steps for you, or you want to avoid it and get powers of attorney put in place, you can schedule an appointment to talk to any of our attorneys about doing either of those. Our number is 888-999-6600. Or you can go online at mcelderlaw.com/scheduling and schedule an appointment that way.